application of English law in relation to the matters of law of trust. English law was received in Sri Lanka through statute in 4 ways. 3 of these are used in trust ordinance. It is necessary at the outset to distinguish among 3 categories. The first one, where a section of the trust ordinance is similar to or identical with the English statutory provision. Second one, where a section of the trust ordinance is a codification of principles of equity which had been developed by the courts of chancery. Third one, where the English law applies in the event of casus omissus. Section 2 of the Trust Ordinance provides for the application of principles of equity, the principles of English equity, where no specific provision is made in Sri Lanka. Not only these section 2, sections 100 and 111 permits adoption of English law in particular instance. Before we go into the section now, we will see something related to this one. When the section 2 operates or any principles of equity is imported under section 2 of the Trust Ordinance, such English authorities are absolutely binding, because when you see the section used the word shall. The words, all the matters with reference to any trust. The words, all the matters with reference to the trust, seem to point to the trust created under Chapter 2 of the Trust Ordinance, while with reference to any obligation in the nature of a trust arising or resulting by implication or construction of law, to those arising under Chapter 9 of the Trust Ordinance. Chapter 2 of the Trust Ordinance is headed of the creation of trusts, and Chapter 9 headed as constructive trusts. This breakup of the words seems justified, since section 82 says an obligation in the nature of trust. An obligation in the nature of trust. Now we will move this to PowerPoint next slide of the PowerPoint presentation. Now this section need to be analyzed after breaking into several parts as follows. Now we will take first breakout of this section. All the matters with reference to any trust. All the matters with reference to any trust. The above words, which describe the trusts created under Chapter 2, are open to two different constructions. It can be argued that these words refer to a trust validly created. That means already trust is created. Therefore, Section 2 would not permit the introduction of English law in determining whether the factors essential for the creation of a trust are present. For example, whether the three certainties was observed. Whether the three certainties were observed. The prescribed formalities were followed, or the perpetuity rule under 110, section 110 of the Trust Ordinance were infringed. Now we will move to other slide here. Then in terms of this section, all the matters reference to any trust in the sense already trust is created. It is only after valid trust under chapter 9 and chapter 2 of the Trust Ordinance has been created that the section would operate. Thus, the English principles would apply only to the matters relating to administration of the trust, not in relation to the creation of trust, such as the powers and liabilities, etc., of the trustees and beneficiaries. There's another alternative view. The alternative view is that there is no limitations on the applicability of the section, and the word trust should be loosely construed to include a potential trust. The view is expressed that the former construction is to be preferred. It's a matter of some practical importance because the Sri Lanka statute excludes all the reference to those trusts referred to in England as trust of imperfect obligation and the perpetuity rule against indefinite duration. And the question arises whether these rules are part of the law of Sri Lanka by virtue of section 2 of the Trust Ordinance. LJM Hure cited that it is submitted that general scheme and logical coherence of the ordinance will be upset if the English law on these points is allowed to intrude. There is a judicial authority for the proposition that Chapter 2 of the Trust Ordinance is complete and therefore Section 2 is irrelevant to the matters which arise in the creation of trusts. The creation of trust. Now we will move to other slide. But no attempt has been made on the lines suggested above to divide the words of the section as they pertain to the trust under chapter 2 and chapter 9 respectively of the Trust Ordinance. Thus, the question whether that section on an interpretation of its language applies to the creation of trust has never been before the court as a specific issue. On the other hand, there is a dicta which is submitted as obiter and per inquirium, implying that the section applies to the creation of trust. The dicta could be regarded as per inquirium because there was no specific issue on the point, and the language of the section was not closely scrutinized. The language of the section was not closely scrutinized and could be regarded as obiter because the reasons given. 1. In these and other cases, rules of law introduced through the operation of this clause related to matters arising after the creation of express trust or with reference to the constructive or resulting trust. And second, the proposition for which there is a judicial authority that Chapter 2 of the Trust Ordinance contains complete provision for the creation of trust was not considered, let alone challenged. And this is necessarily a prior question that must be answered in the negative before Section 2 becomes relevant at all. That's the thing we have explained now. This is a judicial authority for the proposition of that Chapter 2 of the Trust Ordinance is complete, and therefore Section 2 is irrelevant to the matters which arise in the creation of trust. Now we will move to other slide here. This view is expressed that the former construction is to be preferred in this case. There is a judicial authority for the proposition that Chapter 2 is complete. Therefore, Section 2 is irrelevant to the matters which arise in the creation of trust. Now we will see the next issue. All the matters that we have seen, all the matters with reference to any trust. The other part of this section with reference to any obligation in the nature of trust arising or resulting by implication or construction of law. When you see this one, the words arising or resulting, when you read section 82 or chapter 9, you can see these words there. The words arising or resulting make clear that in determining whether a constructive trust exists, unlike in the case of trust under chapter 2 of the Trust Ordinance, English law is pertinent. The sections of the chapter 9 of the Trust Ordinance contain examples of resulting as well as constructive trust. Constructive or resulting trust. The English principles are applicable where there is no specific provisions in the Trust Ordinance or any other enactment that is part of that section 2. The limiting effect of this phrase has been judicially emphasized. Its effect has not always been observed. In Muttalib versus Hamid, A provided the consideration for the land and the conveyance was made to his son's name. Simply we can say here, A paid the consideration for the purpose of purchasing a land but the land transferred to his son's name. Once again, A, the father, paid the consideration, but the property transferred to his son's name. A relied on section 84. Now we will see the 84, section 84, just turn the pages down and see section 84 of the trust ordinance, where the property is transferred to one person for a consideration paid or provided by another person. Once again, where the property is transferred to one person for the consideration paid or provided by another person, and it appears that such other person did not intend to pay or provide such consideration for the benefit of transferee, then the transferee must hold the property for the benefit of the person who has paid consideration. Now, the example or the Muttalib versus Hamid case, what happened? Father paid consideration and the property purchased in the name of the son. Then in this case, when you apply section 84, the first part is all right, the property transferred to one person, that the son, for the consideration paid by another person, that's the father. And it appears that, that's very important, such other person, that's a father, did not intend to pay or provide such consideration for the benefit of transferee, that's the son. Then the son, transferee, the son, must hold the property for the benefit of father. That's the section 84. Then here, in this case, let's say section 84, just you can read here, section of trust ordinance annex, where the property is transferred to one person for the consideration paid or provided by another person, and it appears such person did not intend to pay or provide such consideration for the benefit of transferee, that's a son here. The transferee son must hold the property for the benefit of person paying or providing such consideration. The son argued that English equitable doctrine of advancement modified the rule in section 84. According to this doctrine, where the purchase money was paid by a person in loco parentis. Loco parentis, that you have studied in your Roman law also sometime. Loco parentis, in the sense, the father or brother even, but mostly father is in possession. Then, and the transfer was made into the name of one for whom he was bound to provide a gift, was presumed. Now, what's the meaning of doctrine of advancement? Doctrine of advancement in the sense, that is something like presumption of advancement. If father purchases a property, there's a presumption on the name of the son. The presumption is that father purchased for the benefit of son. That's the equitable doctrine under English law. Then here the son argued that if you apply the equitable doctrine under English law, then the son would be the owner of the property. But the court said that here the doctrine of advancement is part of our law, is placed beyond all question by section 2. The court said that here, you no need to run here and there. Because it may be equitable principles of advancement available in England, but it is part of our local law, part of our law. It is part and parcel of our customs. Then the court said that the doctrine of advancement is part of our law. Is placed beyond all question by section 2 and forms an exception to section 84. Exception to section 84. Further said that although the trust ordinance was only enacted in the year of 1917, nevertheless, ever since the time the British connection begins in this island, therefore, our courts have applied principles of equity to the problem which arise in our courts whenever necessary. And that the doctrine of advancement is part of our law of Ceylon, is placed beyond all questions by the provisions of section 2, which makes applicability or makes applicable the English rules of equity to all casus homicis. Now, in this connection, LGM Hure cited certain issues and certain submission. In page number 46, the resort to section 2 in Muttalib versus Hamid did not result in the incorporation of principles contrary to the trust ordinance. But it is submitted that section 2 should be strictly construed, and practice of referring to this provision except in the event of casus homicis should, for many reasons, be discouraged. And as much as possible, we should not import any English principles by using section 2 for the reasons cited here. The first one, the LGM Hure cited in page number 46 in his work. We have been seeing that it is only where section 2 applies that English authorities are binding, and that otherwise they are relevant but of persuasive authority. But if what is the meaning of this wordings or sentence? If we import under section 2 by using section 2, that will be a binding decision. That's why that should be discouraged. Where the section applies that the English authorities are binding and that otherwise they are relevant but of persuasive authority. Persuasive authority. I think you would have studied binding and persuasive authority in your legal system at the first year. If undue reliance is placed on the residuary provisions, the courts will fetter its freedom both to adopt the law to suit local conditions and also to reject illogical precedent bound rules of English law. In second reason he has given, there's a danger that the provisions will be used to introduce English authorities where they are not in point. They are not in point. Thus, in Vijayavardhana Charitable Trust versus Commissioner of Income Tax, it was held that a trust for the poor relations was an exception to the requirement of public benefit for a valid trust. The Privy Council said in later case that poor relations exception was an anomalous English rule which should not be followed in Sri Lanka. A number of decisions relying on Section 2 have imported English authorities relating to the circumstances in which a trustee transferee from a trustee is bound by the trust and have thus developed in Ceylon law with absolutely no reference to section 65 to 68 that we will study later. And third reason given here, if section 2 is too freely resorted to, it could lead to a primary emphasis on the English law of trust rather than Trust Ordinance 1917. And the fourth reason cited here, it would take a series of decisions to establish which sections of the ordinance contain specific provisions or permissible extent of the reference to English decision to lead to uncertainty. Finally, the final reason, that's a fifth reason given by L.J. Mahure here, the introduction of English rules of trusts, which are sometimes inextricable from related concepts in the law of property and succession. For these reasons, it is submitted, L.J. Mahure says, it is submitted that it is vital that the section to be given in a very restricted application. Now we will see a case decided very recently. That's in 1990. Benedict Wallengenberg versus Hapwarachige Anthony. The plaintiff, a hotel employee, lived with the defendant appellant, a hairdresser, and the mother of 4 children as a man and mistress. They are not husband and wife. Both worked in the same hotel. Thereafter, plaintiff proceeded to Sweden, where he learned the language and received an income about 9,000 rupees a month. The defendant also went over Sweden for a short spell, and she also found employment receiving about 2,000 rupees a month. Plaintiff came to Sri Lanka and purchased a house property in 1976 for 8 lakhs and 40,000 rupees paying consideration out of his earnings. And he came back to Sri Lanka and purchased a property. In 1977, as he had to go again to Sweden, he conveyed the said property, house property, what he has purchased, to the defendant appellant, his mistress, by a deed of transfer, in the attestation to which the consideration of 40,000 rupees was acknowledged to have been received earlier. Now he has purchased for 8,40,000. Now again he wanted to go back to Sweden. Then he transferred such property to his mistress for the consideration of 40,000. The plaintiff sued the defendant for a return of the house property, pleading trust. Now the issue. Now the plaintiff sued the defendant for a return of such property, what he has purchased and conveyed to the mistress, pleading a trust. The defendant claimed absolute title because he has paid money according to the deed of transfer, and that she paid consideration of 40,000 rupees on the deed in her favor. The question was the presumption of advancement in favor of defendant appellant, who admittedly was the mistress of the plaintiff and not the wife. Now, this defendant appellant argued that the equitable principles in England should be imported into Sri Lanka and applied to the case where she can get the property by way of presumption of advancement. Then what happened? The court looked into the issues, and also the learned counsel for the appellant sought to extend the rationale in Mutali versus Hamid to the case of a man and mistress relationship. Now on the Mutali versus Hamid, father paid consideration and the property purchased in his son's name. It's a very genuine matter, and also there, that's a loco-parentis relationship was there. But here, the man purchased a property in his name because he returned, or he decided to go back to Sweden. Then he transferred or conveyed the property by way of deed of transfer to his mistress. And also the deed, in terms of deed, she has paid 40,000 rupees as a consideration for the deed of transfer or for the property. As no such presumption can arise the court said that further, as no such presumption can arise in such relationship in the law of Sri Lanka. Once again, as no such presumption can arise in such relationship in the law of Sri Lanka. Council sought to introduce modern trends of the law of England through section 2 of the Trust Ordinance. But the Supreme Court stated that it does not think that can be done. The decision of the English courts have given rise to qualified trusts based on property concepts and rules of English property law, which is not the law of Sri Lanka. Therefore, court was reluctant to import such development or such equitable principle there into Sri Lanka. Furthermore, the courts of this country have been disinclined to introduce categories of English constructive and resulting trust not mentioned in chapter 9 of the trust ordinance. The court clearly said that we can't import anything and everything into Sri Lanka because there is a different system of property law in Sri Lanka. And finally, we will come to this point here. The principles of equity for the time being in force in the High Court of Justice in England. The principles of equity, that first place, for the time being in force in the High Court of Justice in England. Section 2 has been applied, an English principle received into Ceylon, but there has been no judicial definition and analysis of principles of equity. What is principles of equity? In the light of Keaton's definition, the phrase principles of equity in section 2 may be defined as follows. The rules evolved by the Court of Chancellery and in force in England for the time being today. Then it may be a principles of equity, but today it was accommodated or incorporated into the statutes. Then it can't be a principles of equity today because it is a provisions of the statutes, because it is accommodated into the statutes. Therefore, the rules evolved by the Court of Chancellery, not only that, plus it should be enforced today as principles of equity in England. The where rules of equity repealed by registration, this is one way, and the repeal rule cannot be said to be in force within the meaning of section 2, because section 2 says principles of equity. If it is repealed, there is nothing now. Or otherwise, if the statutory law accommodated or incorporated those principles of equity into the statute, then it can't be a principles of equity today. Then what we have studied today, section 2 that we have seen very clearly. Once again we will see the section very clearly. All the matters with reference to any trust, in the sense, now we can define or we can interpret these words as all the matters with reference to the trust already created. As you know, or we will study later, there are certain requirements to be fulfilled to create a trust. Regarding the requirements to fulfill or requirements to create the trust, you can't import any English principles, because the section 2 says all the matters in relation to, all the matters with reference to any trust. That means trust is created. Or with reference to any obligation in the nature of trust arising or resulting by implication or construction of law. That means it refers the trust arising under chapter 9 of the trust ordinance. trusts ordinance. Therefore, when you talk about express trust under chapter 2, we must say for the purpose of section 2, if the trust is created, then in relation to the administration or management of the trust, we can import equitable principles of England. But in relation to the in relation to the constructive trust, arising under chapter 9 of the trust ordinance, even the creation part, even during the creation or arising, we can say that during that issue also we can import any equitable principle to apply to such circumstances. Therefore, if there is a constructive trust, not only the trust, administration of trust, but also in relation to the arising of constructive trust, we can import the equitable principles or the principles of equity from England. And also we must see one main thing, no specific provision is made in this trust ordinance or any other enactment. Any other enactment in the sense may be a written law or the regulations or rules or notices, anything and everything in Sri Lanka. Then if there is nothing, if there is no provisions in any written law in Sri Lanka, including the provincial statute, everything, then only we must see the possibilities of importation of English principles into Sri Lanka. Further, another condition is there. That's the thing we have seen. Principles of equity for the time being in force in the High Court of England. Presently, or we can say another way, the date on which the dispute is arising, on that date there must be a principles of equity in London, in England. Then the principles of equity for the time being in force in the High Court of, for the time being, that's the time. Sometimes it may be a date on which the problem or the dispute arises here in Sri Lanka, or even the time of consideration of the importation of equitable principles of England. Then we must, these are the restrictions. All these restrictions we must keep it in your mind and import the equitable principles. And also, as the LGM Hure cited in his work, if you import the equitable principle by using section 2, then it is a binding effect. It has the binding effect. It is a binding effect. Therefore, now when you say that from time to time in Sri Lanka courts, we are citing so many English cases. All these cases has some sort of persuasive effect. It doesn't matter, not only here in England, not here from England law, English law, or even Indian cases or English Supreme Court cases, even laws. You can cite. You can cite in our courts. But if you import by using section 2 of the Trusts Ordinance, then it has binding effect. That's why here the section 2 reads like, all matters with reference to any trust or the constructive trust, for no specific provision is made, then shall be determined by the principal. Then it is a mandatory requirement you use the principle. That also, as LGM who recited, that is something binding effect. These are the two cases. I also would like to say or recommend for reading this section, reading this 1991 case, Benedict case. But it may be a little bit difficult because we'll study the constructive trust later. By that time, you will be able to understand better than now. And I think we have completed this applicability of English law by way under section 2 of the trust ordinance. I think that's the end of this section or topic. Then we will see in another topic. Thank you very much for listening this audio.